Good evening, my dear friends. Today I'm going to discuss on the topic The Concept of Law by H.L.A.HART. So, basically, the concept of law is an analysis of the relation between law, coercion, and morality. And it is an attempt to clarify the question of whether all laws may be properly conceptualized as coercive orders or morals of commands. Now, Hart says that there is no logically necessary connection between the law and coercion or between the law and the morality. He also explains that to classify all laws as coercive orders or as moral commands, it is of oversimplify the relations between law, coercion, and morality. Further, he explains that to conceptualize all laws as coercive orders or as moral commands is to impose a misleading appearance of uniformity on different kinds of laws and on different kinds of social functions which law may perform. Further, he argues that to describe all laws as coercive orders is to mischaracterize the purpose and function of some laws and is to misunderstand their content, mode of origin, and range of application. Now, let us talk about the laws or rules that may forbid individuals to perform various kinds of actions or that may impose various obligations on individual. Law may require individuals to undergo punishment for injuring other or individuals. Now, they may also specify how contracts are to be arranged and how official documents are to be created. They may also specify how legislatures are to be assembled and how courts are to function. They may specify how new laws are to be enacted and how old laws are to be changed. They may exert coercive power over individuals by imposing penalties on those individuals who do not comply with various kinds of duties or obligations. However, not at all laws may be regarded as coercive orders because some laws may confer powers or privileges on individuals without imposing duties or obligations on them. Now, Hart criticized the concept of law that is formulated by John Austin in the province of jurisprudence, that proposes that all laws are commands of a legally unlimited sovereign. Austin claims that all laws are coercive orders that impose duties or obligations on individual. Hurt further says that, however, that laws may differ from the commands of a sovereign because they may apply to those individuals who enact them and not merely to other individuals. Law may also differ from coercive orders in that they may not necessarily impose duties or obligations but may instead confer powers or privileges. Laws that impose duties or obligations on individuals, as described by Hurt as primary rule of obligation. In order for a system of primary rule of function effectively, secondary rule may also be necessary in order to provide an authoritative statement of all the primary rules. Secondary rules may be necessary in order to allow legislatures to make changes in the primary rules if the primary rules are found to be defective or inadequate. Secondary rules may also be necessary in order to enable courts to resolve disputes over the interpretations and application of the primary rules. The secondary rules of a legal system may thus include like rule of recognitions, then rule of change, rule of adjudication. Now, in order for the primary rules of a legal system to function effectively, the rules must be sufficiently clear and intelligible to be understood by those individuals to whom they apply. If the primary rules are not sufficiently clear or intelligible, then there may be uncertainty about the obligation which have been imposed on individual. Vagueness or ambiguity in the secondary rules of a legal system may also cause uncertainty as to whether powers have been conferred on individuals in accordance with statutory requirements, or may cause uncertainty as to whether legislatures have the authority to change law. Vagueness or ambiguities in the secondary rule of the legal system may cause uncertainty as to whether courts have jurisdiction over dispute concerning the interpretation and application of law. Now, primary rules of obligations are not in themselves sufficient to establish a system of laws that can be formally recognized, changed, or adjudicated, which is said by Hart. Primary rules must be combined with secondary rules in order to advance from the pre-legal or to the legal stage of determination. A legal system may thus be established by a union of primary and secondary rules. Now, Hart distinguishes between the external and internal point of view with respect to how the rules of a legal system may be described or evaluated. The external point of view is that of an observer who does not necessarily have to accept the rules of the legal system. The external observer may be able to evaluate the extent to which the rules of the legal system produce a regular pattern of conduct on the part of individuals to whom the rules apply. Now, the internal point of view, on the other hand, is that individuals who are governed by the rules of the legal system and who accept these rules of the standard of conduct. So, if you like the video, please subscribe to my channel and please like the video. Thank you.